The Second Amendment is hotly debated. We have a new United States Constitution decision, well, it's a couple of years old now, in Bruen. And Bruen gave us some scaffolding on how to analyze any law that restricts the right to bear arms. Well, one of the laws that restricts the right to bear arms is Florida's law that says a convicted felon cannot possess a firearm. Convicted felons are coming forward now and saying, hey, wait a second, under Bruen, we think that we are allowed to possess a firearm. Now, Bruen had nothing to do with convicted felons, folks. It's a United States Supreme Court case that basically said, we the people have a right to bear arms under the Second Amendment. And if the government's gonna come along and start choking out the Second Amendment, if the government's gonna come along and restrict the right to bear arms, that restriction had better be, legit in light of how the Second Amendment has been interpreted throughout the ages. And I mean, Bruen says you got to go all the way back. You got to go all the way back to when the Second Amendment was written and right around that area and say, did they restrict the right to bear arms in the way that you want to restrict it? Because in Bruen, New York City decided, we're not going to let you carry a firearm unless you can show us that you have some reason to protect yourself. You show us that reason and we'll let you get a permit. That was the issue in Bruen. And Bruen said, oh, hell no, we're striking down this law. We're looking all the way back. And never in the history of the Second Amendment did our Constitution say, or our founding fathers say, only the people that have a legit reason to defend themselves can have a firearm. So Bruen said, hell no, we're gonna set up this new analysis that says, look back at the way we've treated the right to bear arms. Do you see something like this happening back in the day? No? Well then, New York City, you can't qualify people and not give them the right to bear arms unless they show you some reason. Nonsense. That law was struck down. Well, now people are using Bruen to say, well, hey, I'm a convicted felon in the state of Florida. Makes it a crime for me to possess a firearm, and under Bruen, I think that I should be allowed to possess a firearm. The first case to address Bruen in Florida was Edinfield. And Edinfield said, oh, hell no, this law is legit. It's 100% constitutional. Convicted felons under Bruen, under any law, cannot possess firearms. Next case. We have the next case, and it's Gooley versus the state of Florida. Same issue once again as in Edinfield. Somebody comes along and says, I'm convicted of a felony, and now I possessed a firearm. I get arrested for possessing the firearm. Now that's a felony. It's called felony possession of firearm by a convicted felon. And again, Gooley says, under Bruen, I ought to be allowed to possess this gun. Come on, people. Gooley, just like Edinfield, says, hell no. Florida's law is completely constitutional. It's completely legit. Convicted felons cannot possess a firearm. So now, under Bruen, this law has been challenged in Florida several times, and several times the courts in Florida have said, you are a convicted felon, you can't possess a firearm. But what is interesting about Gooley is that all the judges agree that convicted felons cannot possess a firearm even under Bruen. What's funny about Gooley is none of them agree on the reason why a convicted felon cannot possess a firearm. Because you see, one concurring opinion says that this whole analysis of law-abiding citizens have a Second Amendment right to possess firearms. The first judge in Gooley says, law-abiding citizens, that is a nonsense argument, and that is not true. No law-abiding citizen argument for the first judge in Gooley. And then the second judge in Gooley says, oh no, the law-abiding citizen language is a proper analysis, and historically, if you look at it, people who were not abiding by the law and were convicted of felonies were not allowed to possess firearms. So these judges actually disagree as to what Bruen means and where the emphasis on the analysis should be. This is like as clear as mud, folks. And I think that the United States Supreme Court over time have to come up with some tweaks to guide these state courts. But for now, in the state of Florida, we got another decision that says no Second Amendment rights for convicted felons. That's where we sit right now. I suspect the next challenge, folks, is going to deal with the law-abiding citizen aspect. And the next challenge is going to deal with the tweak of, yeah, but my felony was nonviolent. We've seen that in another case I did a video on. Yeah, but my felony was like driving on a suspended license 4 times. I'm not a violent person. Can't I possess a firearm? That sort of thing's going to come up, I think, in later cases. For now, folks, the challenges under Bruen are getting struck down and struck down and struck down, and there are no rights to bear arms for you folks out there that are convicted felons. That's where the law stands right now.